Hello, and welcome to today's event, The Legal Side of Social Media, What City and County Attorneys Must Know. This is Harold Tuck, Senior Fellow for Government Technology. I'm excited to serve as a moderator for today's event. And just want to say thank you for joining us. I know we're in for an informative session over the next 60 minutes. Before we begin, a couple of brief housekeeping notes, if I may. A recording of this presentation will be emailed to all registrants within 48 hours. You can use the recording for your reference or feel free to pass along to colleagues. The webcast is designed to be interactive, and you can participate in the Q&A with us by asking questions at any time during the presentation. You should see a Q&A box on the bottom left of the presentation panel. Please send in your questions as they come up throughout the presentation. Our speakers will address as many of these questions as we can during the Q&A portion at the close of our webinar today. If you would like to download a PDF of the slides for this presentation, you can do so by clicking on the Webinar Resources widgets at the bottom of the console. Also, during today's webinar, if you are unable to connect with your peers via LinkedIn, Twitter, and Facebook, please use hashtag GTLive to connect with your peers across the government technology platform via Twitter. At the close of the webinar, we encourage you to complete a brief survey about the presentation. We'd like to hear what you think. If you are unable to stay with us for the entire webinar but would like to complete the survey as much as you're able, please click the red survey widget at the bottom of the screen to launch the survey. Otherwise, it will pop up once the webinar concludes. At this time, we recommend you disable your pop-up blockers. And if you are experiencing any media player issues or have any other problems, please visit our webcast help guide by clicking on the help button at the bottom of the console. So I need to go a little bit off script because I just lost my connection. So I would need to ask my team if you could advance to the slide after the title slide for me. And as I try to log back on, I will let you know when I catch up. Joining me today to discuss this very timely topic is David Mencken, attorney at Yonkers, New York law firm, Smith, Buss, and Jacobs, LLP, and Neal Chawla, founder and chief executive officer for ArchiveSocial. Can you advance to the agenda slide? Thank you. And again, I'm trying to log back on, and I'm not able to see the slide, so I would want you to be able to read that question and read our agendas, I should say. Thank you. Okay, so I'm trying to log on and also not have a lot of dead space, so I do apologize. So with that, we would need to turn to the poll question. And may I ask you and Neal, since I cannot see my screen at the present time, can you read the poll questions for the audience, please?
Sure, Harold. I'd be happy to. So we are going to introduce our first speaker, David Mencken, and the poll question that we have on the screen right now is, what legal issues and risks are you concerned about when it comes to social media? This is a multiple choice question. First answer, First Amendment speech and the ability to remove and moderate comments, ensuring compliance with public records requirements, the ability to produce social media content for legal discovery, and the potential for mistakes and misinformation coming from your agency. Please, again, go ahead and select each answer here that you are significantly concerned about.
Thank you, Neal. I'm back, and as the song says, all the way live, and I have my screen. So let me introduce our first speaker, please, Mr. David Mencken. He is an attorney with the Yonkers, New York law firm Smith, Buss, and Jacobs, LLP, where he specializes in social media and intellectual property law. He has represented government entities and nonprofits, including fire and EMS departments, on issues including social media, open government, and data security. As a former village attorney for Mount Kisco, New York, chair of the Bedford, New York Zoning Board of Appeals, and member of the Westchester County, New York Planning Board, David uses his government, municipal, and land use experience to effectively represent both government entities and those whose business involves zoning, land use, and municipal law. David is a graduate of Johns Hopkins University and New York University School of Law. He also works in local government as a town justice in Bedford, New York Justice Court. And just before I turn it over to David, let's look at the results of the poll. Almost 71% of you said the First Amendment speech and the ability to remove moderate comments are the legal issues and risks that you're concerned about. Approximately two-thirds of you also thought that ensuring compliance with public records requirements is a major concern. In fact, all of these are over 60%. The ability to produce social media content for legal discovery is almost 62%. And tied with that is the potential for mistakes and misinformation coming out from your agency. So I'm sure that David and Neal will address those issues. And welcome, David, to today's webinar.
Thank you. Thank you, Harold. I appreciate the opportunity to speak, and thank you, everybody else, for logging on. I am going to focus my talk today on the first two, which is how government can control social media and how people and government officials might post to social media, and also what I would call the sunshine laws. First of all, social media is of obviously unquestionable benefit to local government. It expediently and efficiently supports government operations, facilitates public policy discussion, but as we all know, with the rapid advance in technology have come legal issues which, as with all fields of technology, there's trouble keeping pace with innovation. The law just really doesn't keep pace. So I'm going to discuss legal issues of government use of social media which should be addressed by you as government attorneys in time to avoid serious legal complications, perhaps economic liability, and better plan for inevitably more complicated demands for accountability. Due to time constraints, as I said, I can only talk about two things. There are other areas that I think are equally as important that I'm not going to focus on. I'm not even going to mention right now, but I'm going to outline copyright issues, defamation, advertising, ADA issues, access, but we just can't talk about that right now. Most important is may the government limit the free speech rights of citizens on social media sites, and how can they do that? I'm referring most specifically to sites sponsored or hosted by government agencies, such as a government Facebook page. As we all know, social media provides a new way for government and citizens to communicate, such as the government Facebook page or Twitter or Instagram or LinkedIn, things along that line. There are risks both to enabling and to regulating what, when, and to whom a citizen and a government employee can communicate. The question as to whether government control posting on social media, that is, whether it can limit the free speech rights of citizens, is generally determined by what's called a public forum analysis, which was discussed in a 1983 Supreme Court case, Perry Education Association. 460 U.S. 37, if you're looking for a site. The Perry case enumerated three different categories of public forums, or fora: a traditional public forum, and a designated public forum, and a non-public forum. A traditional public forum is someplace like a street or a sidewalk, a place which is traditionally used for assembly and where regulations limiting free speech are subject to very strict scrutiny. A designated public forum is something like a school board meeting, a municipal meeting room, traditionally not used for assembly or debate, but nevertheless designated by the government for public speech. So maybe even a utility pole owned by a city and used for placement of banners which are approved by the city. And then finally, a non-public forum, like a school or a jail or a government intranet, where the government can control expression, but not that which is based on ideology or opinion of the speaker. In New York, at least, where I work, there's no case law and certainly no official pronouncement from a government agency discussing or specifying the category of public forum in which use of social media by the government properly fits. But more than likely, a government social media page or site would be considered a designated public forum if the government permitted the public to comment on the page. There have been only a handful of cases dealing with a citizen's right to use a government's social media site. I can't cite them because I don't have time, but it should be noted that, as you see on my slide, there must be a compelling government interest to restrict participation. It is really appropriate to have a government social media policy so that you can provide for the orderly public participation and the public can know what is expected of them and what is permitted. And finally, there needs to be a neutral moderator who can determine what, if anything, cannot be on the public site. A case which was settled before it could be decided, which shows you how important this area is, was Hawaii Defense Foundation versus City and County of Honolulu. I believe that was a 2012 case. Plaintiff filed a complaint in federal district court of Hawaii alleging that the Honolulu police unlawfully administered its Facebook page in violation of the people's constitutional right to free speech. The complaint asserted that the Honolulu police arbitrarily moderated the page by, of course, deleting comments and banning users who posted or made comments unfavorable to the department and brought up to the front those users who made comments which were favorable to the department. So the complaint asserted that online speech is just as important as citizens airing their grievance in a public park. Just because the speech is virtual doesn't mean it's not protected. Well, that case was settled, but here's a telling point to the settlement. The Hawaii Police Department agreed to develop a policy in consultation with the ACLU regarding public posting on its Facebook page. So, the ACLU got involved in this one. So whether and how to restrict speech by citizens in government-sponsored social media sites, it's not an issue which can easily be resolved. It depends on factors such as the degree of interactivity of the site, the type of speech anticipated, the level of moderation. Clearly, certain types of speech can be restricted, as I mentioned, like speech which is obscene, threatening, discriminatory, defamatory, or off-topic. For other types of speech, it's not so clear that you can really restrict what is on this type of a social media site, and you want to be very careful because there is obviously some liability. Next issue is, what about restrictions on government employees? Public employees are generally subject to diminished First Amendment rights when they're acting in their official capacities and conducting business for the government. A key case in this regard is the 68th case, Supreme Court case Pickering versus Board of Education. The Supreme Court held that in the absence of proof of a teacher knowingly or recklessly making false statements, the teacher had a right to speak on issues of public importance without being dismissed from his or her position. The court elaborated on a two-step process. Is the speech a matter of public concern? And if it is, then there's a balancing test. The interests of the government employee commenting on matters of public concern are weighed against the state's interest in effective government. There's a really interesting social media case involving political speech of a government worker, Bland versus Roberts, 2013 case decided by the Fifth Circuit Court of Appeals on appeal from the Federal District Court in Virginia. Employees of an elected sheriff were fired in retaliation for liking the Facebook page of an opponent. The lower court dismissed the retaliation case, holding that merely liking a Facebook page didn't amount to speech sufficient to merit constitutional protection because it wasn't a statement. The Fifth Circuit disagreed stating, once one understands the nature of what Carter, who is this person who liked the Facebook page, did by liking the campaign page, it becomes apparent that his conduct qualifies as speech. On the most basic level, clicking on a like button literally causes to be published a statement that a user likes something, which is itself a substantive statement. So, what could go wrong? This is where, to me, it gets interesting. Here's a guy who wrote on his Twitter account, "Use live ammunition," and this was in response to the public protesting regarding the Wisconsin public union issues. Here's what happened to this guy. Indiana Deputy Attorney General out of job after live ammo tweet. Officer said, this is from the Albuquerque Journal, officer said his job is human waste disposal. He was involved in a shooting, and Albuquerque Police Department settles a civil case for $300,000 because they brought up his predisposition to a certain kind of behavior. And this was on his personal Facebook account. Tiana Walsh wrote, "So I'm watching the news in Baltimore. I see some large swarms of people throwing bricks. Simple solution, simple, shoot 'em." And what happened to her? Wayne County Assistant Prosecutor resigns over Baltimore Post. And this is what you don't want to have. Oh, here's another interesting one. New York City Police Department asks people in the public to tweet photos. It's a public relations campaign, and here's what happened to them. What could go wrong? Tweeted back, need a lift? The NYPD's got you. Free delivery only at myNYPD. Now, if you're going to take this off and not something positive, then I think you're going to be in some trouble. This all points to what I'm probably not going to have time for, which is my last slide, which is what needs to go into a social media policy. And it's my recommendation, I think it's quote-unquote best practice that local government, city, county, village, town, adopt a social media policy indicating how it's going to deal with something like this, and then stick with it. And I think when you do that, it's a lot harder to go wrong. So with my last slide on this, California town abandons Facebook page and the legal concerns. This is what you don't want to have happen. The town attorney said, I don't know what I'm doing here, and I'm not able to advise my client, so we're just going to take down the Facebook page. Now, with the time remaining in my segment, I want to discuss the second set of topical issues relating to government use of social media. How are what are called sunshine laws affecting the use of social media by government? What kind of obligations government attorneys should be aware of with respect to freedom of information and record retention? And we'll start with the open meetings law. It's universal, I believe. It's in all 50 states. Government business should be conducted in the open, that is, in the sunshine. With very few exceptions, meetings of decision-making bodies must be conducted on notice and in the open. Well, the New York Open Meetings Law, for example, provides in pertinent part, it is essential to the maintenance of a democratic society that the public business be performed in an open and public manner. So without getting into details of the Open Meetings Law, I can tell you that the law does not cover interactions of government officials on social media. Those interactions do not appear to qualify as quote-unquote meetings. To date, there's been no case law, no formal guidance as to whether a government agency's social media activities are subject to the Open Meetings Law. Notwithstanding that, interactions of government officials over social media can look pretty much like a meeting if government matters are discussed, even sequentially, for example, over Facebook or Twitter or email or text message by enough public officers to constitute a quorum. Well, New York is not at the forefront of applying electronic communications to open meeting laws. There are other states which are a little bit more sophisticated. or at least have dealt with this. Tennessee's open meetings law addresses meetings by email or other forms of electronic communication. It seems to cover all the bases which should be considered relevant, like public access, notice, archiving. That's open meetings law section 8-44, but California flat out prohibits serial communications. Its open meetings law provides that a majority of the members of the legislative bodies are not able to, outside of an authorized meeting, use any series of communications of any kind to discuss or deliberate or take any action. So in the absence of clarity, at least among the states, it makes sense to avoid even the appearance of holding a meeting in violation of your state's open meetings law. I think that it's best that government officials not use social media sites to deliberate or to engage in discussions with each other regarding government business, and most certainly shouldn't vote. I'm running out of time, so I'll try to be a little brief. All 50 states also have freedom of information statutes, most based on the federal freedom of information law. All relate to records, but what is a, quote, record has been upended by technology. A post or a tweet is never perhaps reduced to paper, or maybe it's metadata that it should be considered a record, or even the notation that someone is a friend or likes or shares a post may be a public record and discoverable and accessible under FOIL. And it gets confusing. Here's the New York law. New York Freedom of Information law defines as a record any information kept in any physical form whatsoever, but a lot of what we're talking about is not in any sense of the word physical. Now, Washington State's High Court in 2010 held that an email and its metadata indicating the sender of the data are public records. This is a really interesting case, and I believe that Neal is going to talk about it when he discusses the importance of archiving social media data, information, and records. At a September 2006 City Council meeting, Deputy Mayor read aloud an email she said she had received from this lady, Beth O'Neill. Beth said she hadn't sent the message, so she requested a copy to see who did. But before providing the email, the deputy mayor removed the metadata and then deleted the email. So he provided the email, but he deleted the metadata. O'Neill sued, claiming the city had violated the Washington Public Records Act. The Supreme Court held, that's of Washington, that metadata is considered part of a public record, and listen to this, awarded O'Neill $100,000 in damages and $400,000 in attorney's fees. So violations of state public records laws can be quite expensive. In sum, as I mentioned before, is my slide coming up? I'm not sure. But as I mentioned before, we're just not really certain what the state of the law is with respect to social media, so we have to be careful. New York State Archives, however, said, and I think that this would be mirrored by other states, because the technology is new, it's not yet clear to what extent traditional records retention and disposition practices apply to social media content. Well, the deputy mayor of this city in Washington didn't understand that metadata might apply to a social media record, which is foilable and must be retained, and the liability to the town was pretty high. My last slide, which I don't have time to go into, is how to adopt or what concerns or considerations you should look at as a government attorney in adopting a social media policy. I recommend that you take a look at that, and I'm going to defer now to anyone else who wants to speak on this. Neal?
David, thank you very much. Very informative presentation. I am sure some of the issues that you didn't go in depth would either be answered by Neal and or questions from the audience. So thank you so much. Now, before I introduce our next speaker, let's do our second and final poll question, everyone. And the question is, what is your current approach to social media as a public record. One, I don't believe that social media creates a public record. Two, social media might create public records, but we are not using it in that way. Three, we have disallowed comments and responses in order to avoid potential issues. Four, we have employed policies and tools to ensure that we maintain social media as a record. And finally, I believe social media creates public records, but I am not sure how we are addressing this issue. So please take some time and answer that question. And before we go over the results with you, let me introduce you to our second and final speaker. Mr. Neal Chawla is the founder and CEO of ArchiveSocial, a civic tech company that specializes in archiving social media for public records requirements. ArchiveSocial partnered with the state of North Carolina in 2010 to launch the world's first open interactive archive of social media. Since then, ArchiveSocial has enabled hundreds of government entities such as San Francisco, Austin, Texas, and the United States Department of Justice, to name a few, to ensure long-term transparency for government social media communications. The company was selected for the prestigious Code for America Accelerator in 2013 and recognized as a 2014 Cool Vendor in Government by leading analyst firm Gartner. And with that, welcome Neal to the webinar, and why don't you review the results with our audience?
Harold, thank you so much for the introduction, and I want to thank everyone who's dialed in on this Thursday afternoon or Thursday morning, depending on where you're at. As David mentioned, this is has been an area of confusion for the past few years in terms of where social media stands. The good news is that the confusion is clearing, and David's provided some guidance on that, and I appreciate the opportunity to share what I've learned. The big caveat here is what I spend my time doing is working with agencies across the country and being a conduit to share what I'm seeing. I am not a licensed attorney. David is. So I do want to thank David for his participation today. It's a real privilege to have an expert such as him on this call with us, and I look forward to working with him to address your questions at the end of this webinar. Now, we are looking at the results of this poll, and again, it's clear here that the vast majority of folks are in that bucket of I'm not sure what to do about this issue. I know it's an issue. I know that social media creates public records, but I'm not sure how we're addressing it. I will draw the silver lining here and mention that a quarter of you are doing something about this. You have the policies. You have the tools to maintain social media as a record. So kudos to you. Thanks for participating today. I hope to add even more value to fill out some of the knowledge in this space from what we've recently learned. Now, here's a quick look at my agenda. The way I want to approach this issue, again, is to be a conduit of what's happening in the space. So I'm going to share real-life examples. I'm going to hone in on some real case studies, some that have gained national attention, but the vast majority you've never heard about probably unless you've heard me speak before, because this is what's happening in the real world with our customers and agencies we work with in terms of records requests, legal situations. I'm going to highlight those so that you have a concrete basis for how social media is being brought into legal context, how it is being subject to public records requirements. I'm going to focus on record keeping as a fundamental requirement for every single public agency in the United States using social media. I'm going to make the case to you that this absolutely has to be done. A few of you, I think about 15%, said that you are using social media, but not in the way that it creates records. I'm really going to push on that a little bit to ask you to go back and reconsider what's happening on social media. I'm going to give you a few examples for you to think about there. Time permitting, I want to give you a quick demonstration of what it means to have record keeping of social media, how it can empower the process of producing those records, whether you're the attorney, the public information officer, a clerk, anyone who would be involved in producing that information. And again, of course, we want to be there to answer your questions. Let me kick off a segue from where David ended into the public records issue and start with the law. What I've brought up here right now is just one example. I know we have participants here with us today from all across the country. California is a big state. We have a lot of participants from California, so I picked this out. Just to give you an example, while the law the vast majority of laws have not been changed to talk about social media in a specific detail. The reality is that the laws were broadly written decades ago to account for this change in technology that would inevitably happen over time. Virtually every public records law you look at, like the one here in California, has a phrase that defines the record as regardless of physical form. In other words, a crime tip is a crime tip. It doesn't matter if it's on a piece of paper, in an email, or in a tweet. It's a crime tip. A citizen complaint, same thing. And so the laws have been written in this way, and that's how 2 decades ago, when email became a essential part of our day-to-day, that's how we quickly realized that email is in fact a public record that needs to be maintained. Hopefully each and every one of your agencies is archiving their email today. We're at the same juncture here with social media, regardless of physical form. So what I'm going to focus on here is how the social media that we're seeing agencies, how social media content that agencies are producing, how that content does constitute record, and what are those scenarios. Now, to be clear, when we've talked to folks in California over the past few years, even as of last year, we would hear from city and county attorneys that no, social media is not a record. We haven't necessarily seen that kind of laid out. The good news is that if you actually do a search, there is a group of attorneys across California that have shared some knowledge, and you can actually do this Google search for this phrase, social media sites are subject to the California Public Records Act. If you do the search, you'll find dozens of cities, municipalities that have adopted this language. So there's a lot of knowledge sharing that's happening to emphasize that actually, yes, social media does fall under the public records requirements. And even better news is across the country, departments like the Secretary of State or the library or the archives of state, they've come out to interpret the existing law to say, yes, actually the way the law is written, social media does produce public records, and when it does produce public records, you're responsible for maintaining those. And California, again, is a good example here, where earlier this year, CalRIM put out guidance talking about the cases in which social media can generate public records, and then made it clear that if and when social media generates public records, you must have a plan to export those records from the social media site. You cannot rely on Facebook and Twitter for this data. And we've seen this happen, again, now a few dozen states. One more example I'm going to highlight here that's actually not even in my slide deck because it's so fresh. Out of the state of Wisconsin, just a few weeks ago, the Attorney General of Wisconsin published guidance, and we can provide this link after this webinar, detailing this issue. And in that guidance, they discussed that if an authority uses social media, the content must be produced if it is responsive to a public records request. And in fact, if you are requested to produce social media, this not only includes live content, but even content from the past. The guidance also goes on, again in Wisconsin, to say that if an authority makes use of social media or if employees use mobile devices, the authority should adopt procedures to retain and preserve all such records. So again, just 2 data points for you out of many now that are across the country in terms of how the bodies that should be making statements on this issue have come out and said it, and oftentimes the people that we work with are not even aware that the Attorney General or the Secretary of State is actually taking a stance on this. So again, I'm going to be a conduit of information here. That's the law. Now, some pushback that inevitably will come up internally, especially with the records management team, is that, look, not everything on social media is a record. That's a fair point, but even if everything is not a record, something can be, and you have to have a plan to get that data in your control. And again, just like email, not every email you send is an important record that would somehow find its way in a legal situation or be a public record, but there are enough emails in there that you retain your email. Social media has now crossed that threshold, and I'm going to focus on the examples to really make that case to you. Now, the types of scenarios in which we see social media generating records of value, and again, for those of you who say we're not using social media in that way, if you've ever had an emergency, whether it's a natural disaster or a local crime, I'd ask you to think, what role did social media play in that event, and what role should it play? If it played any role whatsoever, it's likely that you are using social media in a manner that generates records. We've highlighted a bunch of examples here, most prominent the Boston Marathon bombings. In fact, the world's journalists turned to the Boston PD's Twitter feed as the live source of information. And to really make that point, when the Boston PD finally caught the terror suspect, the very first announcement of catching that suspect came out as a tweet. It wasn't in a press release. It wasn't in any kind of formal announcement. It was a tweet. And so those are real records being generated with important information. We have other examples here in the city of Durham, where we're based out of in North Carolina. 911, the phone lines went down, so nobody could call 911 to the phone system, and the city resorted to Twitter and Facebook to inform the public of how to get in touch in case of an emergency. You may not anticipate that happening, but when it happens, it makes perfect sense to use Twitter and Facebook, and you are going to generate content that is of record value. And then beyond public safety and emergencies, day-to-day, every single agency that's using social media, fundamentally, I believe, is on there for one core reason, and it's the core reason that that agency exists, which is to serve the public. Social media is how you communicate with the public. So if you're using it, you're there to serve the public. Get information out, also get information in, receive that feedback. So think about all of your departments. If they ever receive questions or complaints, if they're ever providing clarifications, that's generating records that may fall under your retention schedules. This is a brief example where a woman in Texas was trying to call the Department of Transportation. She couldn't get to the phone line, so she started tweeting, and it turned out that the phone number that was printed out for the DOT on a physical mail-out, that phone number was wrong. And the only way that the citizen had to get in touch and inform them that she thought was convenient was to use Twitter. And in fact, she got the information to the DOT. They corrected that phone number, and all of this is documented on Twitter. This kind of stuff happens day in and day out. You may not think about it. This may never lead to a legal situation, but it certainly has some bearing as you review retention requirements. And finally, I can make the case to you all day that social media is a record, but the question is who's asking for it? Well, here's one very prominent example from last year where the Seattle Police Department uses Twitter to essentially relay, auto-post the crimes and police incidents that are happening in each and every police beat. A citizen in Seattle was paying attention to these feeds and noticed that occasionally the Twitter feeds were missing information that he expected to be there. So he knew that a police incident happened, but it wasn't on the Twitter feed. And so he started tweeting to @SeattlePD. And a few tweets in, he just said, I want the archives of all of your Twitter feeds from your perspective, and please consider this a Public Records Act request. If you think about this, this is a public records request for social media, using social media. This is a sign of the times. This is a sign of the changing expectations that citizens, frankly, should have, given how we all communicate today. Seattle did say we can't accept a public records request via Twitter, but you can go to our website. But they did acknowledge that this is a true public records request that they would have to fulfill, and they said, give us 3 weeks. And essentially the citizen was trying to understand, can you rely on these Twitter feeds? Did this content go up? Was it removed later? All these kinds of things. So he wanted Seattle to produce the feeds because he couldn't validate it anymore looking at Twitter himself. Now, for those of you who are involved with public records requests, you might say, well, that's interesting, but it's crazy, and that's never happened to us before. I don't see that happening. I would ask you to take a step back, actually, think about the requests that you are receiving, because oftentimes you get a request that is scoped to a very particular incident or need, but it's very broad in the type of content it's requesting. So it may say, we want all notifications of the street closure. Well, more and more, Twitter and Facebook are a great way to notify that streets are closed, especially during times of emergencies or when that's a last-minute thing that's happened. That's how you get the information out to people. All notifications includes social media. And so when we talk to our customers, they've recognized that for a long time they've been receiving these requests. They didn't put it together that social media should be produced as part of this request, and that's been a gap, and they've been able to fill it. I'd ask you to think about your agency. At some point, someone's going to realize that actually when I made this request, most of what I should be getting is off of your Twitter and Facebook sites and not necessarily a press release anymore or a public posting on your website. So those are the ways we're seeing that records to be requested in a broad sense. I'm now going to shift gears and give you some very, very specific examples. Hopefully I've generated I've turned on some light bulbs, or maybe made you want to ask some clarification. So please continue to add those questions to the Q&A box. One case study that David actually touched on, I want to come back to it, is a situation in Washington. The city of Shoreline basically had a public records request for email where it was around an email that had been forwarded. The city could only produce the forward but not the original email, and therefore it didn't have all the technical metadata that the original email would have had in terms of who sent the original email and when it was sent. It was really just the forward that they could produce. The Supreme Court did rule that the city was at fault here for not maintaining the original record with the original metadata, not being able to produce it. They were fined, and it cost over $500,000 to settle this case. The analogy here is that social media it has metadata as well, and as you think about record keeping, you need to think about keeping a good record versus just a record. In fact, if you look at a tweet, some agencies have resorted to taking screenshots or using technology that wasn't really built for social media, so it takes a snapshot, but it's not an authentic capture. A tweet has 140 visible characters at most, in this case 126. But even a tweet that's 140 characters has more than 2,000 characters of metadata. Again, that embedded technical information about when it was sent, who sent it, what are the user IDs, if there's location information, what is that. All that information that you don't see that is part of the record and now has been ruled upon in states like Washington and Arizona, that information could be requested as part of the public record and should be produced. So not only do you need to think about record keeping, but you have to think about the fidelity at which you keep these records. Now I'm going to just take provide a quick overview of the case studies that we've seen from our customer base. I'm going to start in South Florida, where one of our customers, information had been posted on their Facebook page about a local company. A law firm had indicated that the local company was a scammy company, that they were engaging in scams. That information was posted on the police department's page. The law firm, the company in question here found out about it, complained, and said, "Wait a minute, we're not a scam. Take that off." Well, the police department complied. They removed this information about the company being a scam. And then the company came back a few weeks later filing lawsuit for defamation, or not actually filing lawsuit, filing a discovery request to say that we're notifying you that there is going to be a discovery request for this, for a potential lawsuit. And what we want you to do is produce every posting that called us out as a scam, including the ones we already told you to delete. So record keeping has to be there. This is not even necessarily a public record request. This is more of a civil type lawsuit. But by Florida law, even though the police department removed that content, they should have kept a record. And by public records law, they were obligated to. And so to start that discovery request off, if they had not been keeping records, would have been a really poor way to start that legal situation. Fortunately, they had been archiving. They were able to produce that information, and hopefully they'll be able to navigate the rest of that case. On the other side of the country, we have a customer in California. In fact, they were not our customer, but they had just started a free trial. And this city, Santa Barbara, was coordinating a gun buyback program. This is a city program that the police department was helping run. And the Facebook page had gone crazy because this is a controversial issue. And shortly thereafter, the NRA actually issued a public information request for all of the content related to the gun buyback program. The gentleman at the police department that was coordinating social media fortunately had started a free trial of our archiving solution, was able to use it to produce the content and get the information to the NRA for the public records request. Nothing ever came out of it, fortunately. But he did publish a case study with government technology talking about how he would have really been in trouble if he didn't have some kind of record-keeping procedure in place, that he would have been scrolling through Facebook and would have likely missed something. And you can download that case study. We'll go to the corner of the United States, Spokane, Washington. This is actually a case from a few years ago now. One of the most basic things that every municipality does or every government agency does is on social media, they communicate about the events that are happening in that region. It's an innocuous activity most of the time, but being a government agency, you are subject to litigation. And unfortunately, what happened is Spokane had helped promote this kayaking trip on which a young man died. And the plaintiff's family actually issued a lawsuit saying that this kayaking trip should not have happened at this time due to weather conditions. And they made a request in the lawsuit for Spokane to produce all of the Facebook postings across 2 years related to their promotion of this event. And again, Spokane was able, in a few clicks, to be able to produce information, but they published a case study with government technology because in the state of Washington, you have to be able to respond to a request within a certain amount of time or you get fined. And Spokane indicated that without some kind of archiving solution, they may not have been able to respond to that request in a timely manner. Now I'm going to come back to the center of the United States, another case study, San Marcos, Texas. And I'm kind of going between public record situations and legal situations. San Marcos is really interesting because they had a website hacking earlier this year where somebody brought down the website for 4 days, a really serious situation. And the FBI was brought in to help investigate. And it turns out that the person that brought it down had actually taunted the police department a few days earlier on social media. The police department had moderated that content. They had removed it. And then the website came down. So when the FBI investigation started, The police officer said, well, somebody did taunt us on social media, but we deleted that information. There's nothing we can do about that now. And luckily, the director of communications had put archiving in place and said, wait a minute, hold on, you said you deleted something, but we have an archive. And was actually able to produce those records to assist in the FBI investigation. And finally, I'm going to come right back to the East Coast, Vineland, New Jersey. This is a situation where the attorney in that region had asked the police department to stop allowing comments to show up on the Facebook page. So they set up some filters and they actively removed content. And so only at this point, they're only just putting their content out, removing everything from citizens. Well, a citizen did file a public records request based on that and said, you must be hiding something. Please produce all of the comments that should have showed up on Facebook but didn't. And by the way, I'm going to issue this public records request once a month. And the citizen follows through with this. And so Vineland ultimately did this manually for a few months and ultimately decided that it was important to have an archiving technology in place to be able to produce that content and respond so that this officer was not bogged down with scrolling through Facebook hours upon hours. So these are the kinds of cases that we're seeing. Again, I strongly encourage you to think about record keeping. I'm actually going to skip ahead here and just suggest some next steps. If you're an attorney, I would highly recommend you to talk to your communications department, your IT department, to find out what they're doing today. The vast majority of you indicated that you're not sure what's happening in your agency. Please go find out. Raise this issue. It sounds like everybody on the call thinks that this content can be a record, which is great. And find out what your communications team is doing on social media and find out if this is something you need to address. You certainly want to include records retention in your social media policy. I know we're getting some questions about that. We can provide a policy template that we've compiled from other agencies to be as comprehensive as possible. You do want a disclaimer on all public profiles so that citizens know that content will be retained for public records requirements. And absolutely, if you're an attorney or you're involved with records requests, think about record keeping and ask yourself the question, if you were to get any one of the requests that I just overviewed here in the last few minutes, how would you respond to that today? What do you need to do to be able to respond to that? Now, there are municipalities that have launched open archives that you can look at, but I'm going to put up my contact information on the screen. Feel free to reach out to me if I can be a resource to you. I know we're coming up on questions. I do want to take just about 90 seconds here to do a quick screen share and highlight what it looks like to have technology to solve this problem for you and solve it very easily in a very cost-effective manner. And so I'm going to go back to San Marcos. Not only do they have that FBI situation, but San Marcos, as much of Texas has encountered, San Marcos has encountered a great amount of flooding this past year, both during Memorial Day and Halloween. And I want to talk about archiving and how important this is because when these floods happened, like happens with most emergencies, soon after there was a flood, I hate to use that word, no pun intended, of public information requests, largely from journalists. And so San Marcos had these emergencies. They used social media to its fullest to protect the citizens, but then they had to be able to produce information about the flooding right after that. So I'm going to do a search here. This is their archive. And you can see what it's like to actually navigate record keeping around social media here. In San Marcos' archive, they have nearly 800 different records related to flooding on their social media, just really from this year, and all sorts of content from across Facebook, Twitter, YouTube. I'm going to highlight this date range section down here at the bottom on the left side. You'll see, again, the vast majority of this content happened in the May-June timeframe with Memorial Day, and again, the October-November timeframe with Halloween. What you want to look for in an archiving solution is a solution that helps you easily navigate thousands upon thousands of records. So here you can just drill down to that date range right away. You can find some content. One thing you have to keep in mind with social media is that's a conversation. So we might find a comment, but you really need to be able to make sense of that comment in the context of the entire conversation. So San Marcos, when needed, was able to find content and then reproduce the actual conversation around it. And this conversation, if I were to spend 5 minutes here, I could expand out hundreds upon hundreds of comments. You want to be comprehensive in that capture. Here you can see that San Marcos was using social media to inform folks of a funnel cloud as quickly as possible. A lot of information came out from people about where to find shelter. San Marcos participated in this conversation. Again, this could easily find itself in a records request. Being able to drill down that information and then easily export it out in a format such as PDF if needed, so that your communications team, your attorneys, you're not bogged down after a crisis like this with producing records. You're able to produce it and focus on what's important. And that's what this archiving technology is all about. One last thing I'm going to highlight here. We recently, because of technology advances, were able to employ technology that automatically detects when content is deleted from Facebook, and it tags that in these archives. This is a real concern, especially with First Amendment issues where your folks are removing content. What we've discovered is that while people think they know when content is being deleted, content is being deleted all the time. I'm just going to give you a quick example here because this has been live for about 2 weeks. Being able to, in an archive, find everything that's been deleted, because we actually have customers now that are getting public records requests from citizens saying, hey, I posted something, you removed it. I'm issuing a public records request for everything that you've deleted in the last month. This is an example from San Marcos where they just accidentally posted a bad link. A citizen noticed it that quickly, and they ended up deleting the post. And no one may have thought anything about this, but we capture it in case it ever comes up. When we look at our customer base, we're seeing right now about a deleted post per customer a week, which may not sound like a lot, but in a year it could be 50 posts for one on average per customer. But in fact, if you look at certain customers, we're seeing customers that have had dozens and dozens of posts deleted in the last few weeks. So the average is about one, but certain customers are encountering a lot more, and many of which they're not even aware of. So this is something to be thoughtful about as you consider your policy and moderation and removal comments. So with that, I'm going to hand back to Harold, and I really look forward to addressing your questions.
Neal, thank you very much, my friend. Excellent presentation, and I enjoy this because I learn. So we want to be respectful of your time. We're getting real close to the top of the hour. Many of you have asked about getting copies of today's presentation. No need to worry. Within the next 48 hours, Government Technology will indeed provide you with a link to the recording for your reference and also for sharing if you would like. So let's just get right to the questions, gentlemen. You could take turns. Some may be more appropriate for Neal, some for David. I'll leave that up to you all. Here's a question. Do lists exist that identify all metadata related to each category of records? And how would you know what to provide in response to a Freedom of Information Act request? So I think this is a tag team.
I think this is a real good question for Neal.
Okay. All right, Neal.
Fair enough. I'm happy to jump in on that. No, there aren't specific lists. Now, when you talk to records managers, you have to be careful about what you mean by metadata, because there's actually two different interpretations of that. From a records management standpoint, once you have a record, again, it's on Facebook and Twitter, it's not really in your control. You need to get it in your control with some kind of archiving. Once you have a record, records management practice is to annotate that record with information, and that's what oftentimes referred to as metadata. So our customers now are annotating information that may be related to elections, for example, or if they're deleting something, they might not only let it get marked as deleted, but they may tag it to indicate why it was deleted. That kind of metadata is important from a records management standpoint. The other metadata that I talked about is the technical record metadata, which is if you look at an email, you may read that email and see 3 sentences on your screen, but underneath that email, if you were to look at the source of that electronic message, is all of the data about how that email was transmitted, what time it was transmitted at, what were the IP addresses. That's also metadata. Another example would be with files. A file on your computer, you might have a Word doc. A lot of times you're concerned with the content of the Word doc, but the metadata of that Word doc, again, are those file attributes of when that file was created, when it was last modified. And the case studies that David and I touched upon were really about that technical metadata. Who sent that email, when was it sent? There's another case study around a file was produced, and there was a question about when it was actually created. And that's the technical metadata that spells that out. So that's all that I'm aware of. I don't know of any other specific listings, but it is in your best interest with capturing social media or anything else to have the authentic record and not to settle for screenshots or a solution that converts the data and may have data loss.
Thank you, Neal. And that question was from Ann. Ann, thanks for submitting the question. This question is from Jennifer, and she asked, and I know this one you can jump into, David, because of the last part of the question. So it's a multi-part, so here we go. We receive several crime tips a week through Facebook. I write the tips up through our Crime Stopper program, which is an anonymous program. If someone sends us a message to our Facebook page that only we see, Is that something that an attorney can subpoena? David?
I would say that it is something that an attorney can subpoena unless on a state-by-state basis there is some overwhelming reason to keep that information confidential. But otherwise, I see no reason why this information would be protected from disclosure.
Okay, thank you. Neal, I've heard you many times, even today, address what this next question is about. So I'm going to toss this over to you, and this is also from Jennifer. And Jennifer, thanks again for attending and asking these thoughtful questions. The question: we're a large city police department. Our question is it okay for us to delete posts and ban subjects from our page for making offensive, obscene, or threatening comments?
Well, I'm happy to address that based on my knowledge in the space. Of course, I would ask David to add on. But basically, we have a policy template that's been put together by looking at several public agencies out there and how they're approaching this issue, and then we've vetted it with city and county attorneys. And the broad answer here is yes, if you have a policy, you want to define that forum, as David mentioned, as a limited public forum, so you have some rights there. And you have to be very clear about how you're enforcing it. So something that's profane, obscene, if that's in your policy, from what I understand, you should be able to remove that. That's very different than someone being negative and, say, just criticizing your administration or criticizing your sheriff. Now, that's not, even that may be offensive to that individual. It's not broadly offensive to the definition of that word. So you have to be careful between those two. One thing I want to be clear about, though, is even though you might be able to delete it with this policy, you still have to have the record keeping. And actually tying this back to the previous question about the subpoenas, just so everyone knows, Facebook has a page for law enforcement about issuing a subpoena. What they say on there is that, yes, you can issue a subpoena, but if anything's been deleted, we can't help you. And this is really interesting because the person who asked the last question mentioned getting private messages with crime tips. One thing that we've seen is that citizens might comment or message you, but they can change their mind and delete it. So you might get that message before you can even document it off of Facebook. They may change their mind and say, you know what, I don't want to be associated with this, delete it. And now Facebook can't even help you, even if you issue a subpoena.
David,
do you want to clarify? Yeah.
No, I think that you've done it correctly.
Okay, well, we're almost out of time, so let me jump to another question or two, gentlemen, if I can. Thank you again, Jennifer. This question is from Stephen, and thank you, Stephen. What kind of social media policies should county attorneys have in their employee manual? David, you want to start us off with this?
Well, I'll start that. First thing you have, the easiest for me to mention, because it's at the top of my thought process, is you should have, number one, it's not exactly a social media policy, but it ties to that, a bring your own device policy. What are you allowed to do on your own laptop or iPad or cell phone, and what kind of information should you be permitted to deal with on that? Most important, though, from the social media perspective, is the manual or the social media policy should state what the limitations are. And I assume you're talking about your county attorney's office, of how the county attorney's office personnel can use social media both internally, meaning they're posting as government employees on their government social media site, and even what kind of social media posts the attorneys or people in the attorney's office can use in their non-work capacity. And I'll give you a very quick example. During the Charleston shooting, a member of a volunteer fire department someplace besides Charleston posted a very offensive reference to the mass murders on his own Facebook page, and he was fired or terminated from the volunteer fire department, the concept being he was a public employee, and as a public employee, even though a volunteer, what he did on his own site could be controlled if particularly egregious by his employer. And I believe that that should also be on a social media policy.
Thank you.
There's forms.
Okay. Yeah, we're out of time, but before I thank our sponsor and our guest, I do want to ask this question because a lot of you have asked it. Neal, how much does ArchiveSocial cost, and what does the installation process involve? Can you do that very briefly, please?
Sure, I'd be happy to. I know we're out of time here. Archiving technology, actually, I think people are surprised by how easy this is with the fact that social media data is in the cloud. So our pricing is transparent on our website. If you're interested in our company in particular, I'd encourage you to go check that out. Broadly speaking, though, our customers, the vast majority of them, spend less than $5,000 annual, and they set this up in less than 30 minutes. I kid you not, and it's a protection that's in place and sort of runs itself.
Thank you very much. I want to thank our speakers, David Menken and Neal Chawla, very much for joining us today. A special thanks to our sponsor, ArchiveSocial. I apologize for running over, but there's no exception when you have great content, great speakers, and an attentive audience. We hope to see you soon at another government technology webinar, and thank you for joining us today.